High Court in Pretoria today is set to hear the main application for the Society for the Protection of Our Constitution over illegal miners who are in Stilfontein refusing to emerge there. The court on Saturday granted interim measures pending the finalization of the main application, which, in summary, ordered that the mine shaft in Stilfontein must be unblocked for emergency personnel and that no one should block it. In fact, the matter stood down on Tuesday to allow the judge and the applicants to go over the answering affidavits filed by respondents. Watching those developments is SABC News reporter Kenny Maphanga, who joins us now live. And Kenny, once again, it's this tension between the constitutional rights of those illegal miners and their obligations, legally speaking, that's likely to play out in court there today.
Well, indeed, good morning to you, Ayanda, and to the viewers once again. Shortly, you'll be seeing the final application or the main application of the Society for the Protection of Our Constitution, seeking that final relief in the form of an interdict, which would advance those Chapter 2 Bill of Rights that they are arguing for in this very complex issue, stating that the right to life and the right to dignity, those are the prominent rights that they have highlighted in their application, are at risk while those suspected Zamazamas are underground in that Stilfontein mine shaft. Now, you may remember on Tuesday that application was expected to continue. However, the government entities that are cited in the papers, that is DMR and SABC, have filed their opposing papers asking the court to dismiss the application, stating that this is not a scenario where these fundamental rights are being infringed upon. And they further argued that they will demonstrate to the court that the suspected Zamazamas are able to rise to the surface or escape, and that they are voluntarily, allegedly choosing not to do so to evade arrest. They'll argue that none of these rights that have been advanced by this group that is representing human rights activists have been infringed upon, and will call on this court to dismiss that application. Of course, when the court, or rather the applicants, came on Saturday for those interim measures, the circumstances, Ayanda, were very different. And of course, they got those interim measures which ensured that there was an end to that blockade and that emergency personnel could get into that mine shaft in order to provide them with the necessary humanitarian aid. However, as we speak today, we know that those rescue operations are ongoing at the mine shaft in the northwest. They are receiving forms of humanitarian aid. Of course, there are some difficulties with specific issues such as healthcare, as well as assessing whether it is safe for some of those government entities and their staffs or officials to make it down that shaft. So essentially what they will have to argue for to get this interdict, they'll have to establish a clear legal right, show that there will be irreparable harm suffered if they're not granted that relief. Of course, they'll also have to show that the balance of convenience favors them as the applicants. And then, of course, also show that there is no alternative remedy or relief except approaching this Gauteng High Court in Pretoria. As I've stated earlier, Ayanda, it will be tricky to balance these rights between these opposing views of the applicants and the respondents, because the initial circumstances upon which those interim measures were granted has drastically changed as we speak today, Ayanda.
Absolutely. We'll be watching that legal battle continue in the High Court in Pretoria. For now, Kenny Maphanga, thanks very much indeed.